Hi, I'm Emily, and I am here with Maya Murphy's attorney, Eva Marie Franco Fox. Attorney Fox practices at Maya Murphy's office in Westport, Connecticut, and is admitted to practice law in both Connecticut and New York. My question today for Attorney Fox is, how can I ensure asset protection within my Connecticut prenuptial agreement?
Prenuptial agreements in Connecticut are often drafted with the intent of providing asset protection for the parties, and this applies to postnuptial agreements as well. Often, the reason why the parties enter into these contracts is specifically to provide some kind of asset protection. The Connecticut Premarital Agreement Act defines property as an interest, present or future, legal or equitable, vested or contingent, real or personal, tangible or intangible. So this really provides a very comprehensive definition. It covers all kinds of different forms of property that the parties may either own at the time they enter into the agreement or when they're getting married, or that they may acquire during the course of the marriage itself and have in the event of a dissolution. It really is meant to cover everything. So what are some examples of this? It could be real property, it could be life insurance, it could be financial accounts, including bank accounts, investment accounts, retirement accounts. It can include, as it says, personal possessions such as family heirlooms, jewelry, artwork. It really is meant to cover all bases for the parties. Now, what can the agreement say about all of these different kinds of property? How can it offer protection? The agreement, first and foremost, really should acknowledge and address the difference between premarital assets and assets acquired during the course of the marriage. Premarital assets are assets that the parties own prior to the date of marriage. They're bringing those assets into the marriage with them when they get married. Assets acquired during the course of the marriage is just as it sounds. They're assets that are acquired by one or both of the parties after the date of marriage. Now, the agreement can treat premarital assets or assets acquired after the date of marriage the same or differently, and it's really up to the parties how they want to treat those assets. But either way, the agreement should still specify and acknowledge that there may have been premarital assets and that there may be assets acquired during the course of the marriage, and this is how we're going to treat them. If the agreement is silent on, for example, premarital assets, it may leave a question for the court or for the parties at the time of a dissolution or in the event of one of the parties' death as to what their intent was. Are those premarital assets going to be considered separate property or joint property? So this is another issue that the agreement needs to address. What is separate property and what is joint property? Separate property is generally considered the property of one of the spouses, and it's usually not subject to any kind of division in the event of a divorce. Alternatively, joint property is generally considered property of both of the spouses. They both have rights and obligations to it, and it is generally subject to division in the event of a divorce. So the agreement needs to address whether or not the premarital assets or the assets acquired during the course of the marriage are going to be considered separate property or joint property. And again, they can be treated similarly, the same way, or they can be treated differently. But either way, it should be in writing and it should be memorialized. It's also important for the parties to go a step further. They really should be addressing additional issues or circumstances that may arise during the course of the marriage. So, for example, what happens if they commingle their separate property asset that's not meant to be subject to division or not meant to be jointly owned? So, for example, what if the assets that are premarital assets are supposed to be treated as separate property, but they're put into a joint account? Does that automatically convert it to becoming a joint asset? How is the agreement going to define joint assets to help them really determine when something converts from a separate asset to a joint asset? Now, the agreement can specify that something's only a joint asset if it's in joint name or if both parties contribute financially to it, and it should also address what happens in the event that the parties are contributing unequal amounts. Is it still considered a joint asset? Is it still owned 50-50, or is it going to be owned in proportion to how they contributed to it? Alternatively, some agreements say any asset acquired by either party after the date of marriage is going to be considered a joint asset, regardless of who contributed to it financially, regardless of how it's held, how the title is held. So it's really important for the agreement to specify what is the actual intent of the parties so they can act accordingly and ensure that they're in compliance with their agreement as far as what they intend to do when they're acquiring assets, buying assets, selling assets, transferring or encumbering assets during the course of the marriage. So, to the extent that a party may put a separate asset into a joint account, the parties need to understand what the ramifications of that could be. Does it mean that you're now waiving your rights to say that that is a separate asset? Or does it mean that you can still go in and withdraw your separate asset component out of that account? Similarly, what happens if a party uses a separate asset for the acquisition or purchase of a joint asset? So, for example, the parties specify in their agreement that premarital assets are going to be considered separate property, and assets acquired during the course of the marriage are going to be considered joint property. Well, what if they're purchasing a property, they're purchasing a house, for example, and one of the parties takes money sitting in a premarital account that's supposed to be a separate asset and uses it for a down payment on that house? Is that then going to convert it to a separate, to a joint property? Or in the event of a sale, is that party entitled to some kind of reimbursement for their down payment? So it's really important to contemplate all these issues, discuss them, negotiate them, and include that in the agreement. Otherwise, you may be in a situation where you are getting divorced and you're arguing over who has rights and obligations to certain pieces of property, when the whole point of preparing one of these agreements is to prevent these types of issues. You could be litigating for years over something that could have been resolved simply by including a sentence or two about how you were going to treat certain assets. So really, it's incredibly important to consult with an attorney during the drafting process to make sure that you don't fall into one of these issues where your agreement is insufficient to really address your needs and concerns and future circumstances of the parties, and it leads to uncertainty and disputes in the future. In addition, there are certain types of issues that are commonly excluded or forgotten during the drafting process. And this could be because either the asset is of a nominal value and the parties just figure it's not worth including, or it could be because the parties just aren't contemplating that this may be an issue in the future. One common issue that's forgotten is not just sale proceeds, but what happens in the event that an asset appreciates or accrues equity during the course of the marriage, particularly an asset that's intended to be separate property. There could be a situation where your agreement addresses what's separate property, what's joint property, and even what happens with sale proceeds, for example, but it may not address what happens if one of your separate property assets appreciates in value. Are both parties entitled to that appreciation, or is it just going to belong to the party who owns that asset as a separate property? This is really a litigated issue, particularly when both parties are contributing to that asset and causing the appreciation. So, for example, the parties move into a real property, a house, that was a premarital asset and is supposed to be considered a separate asset. And they're both contributing to the mortgage, they're both contributing to perhaps renovations, they're both contributing to the upkeep of the house financially and in ways that are not financial, non-monetary. And it causes an increase or an appreciation, and then the asset is sold. Are both parties entitled to that appreciation or that equity that accrued? It's really important to determine in advance how that's going to be treated. It could really affect how the parties are going to conduct themselves in the future and help them know what their rights and obligations are moving forward. It's also another issue that's commonly forgotten is business interests. In Connecticut, business interests are considered assets, and parties often forget to include their business interests. They may disclose it in the financial disclosure, but they would forget sometimes to include it within the body of the agreement. And sometimes business interests really warrant their own provision, their own section within the agreement. Sometimes parties are in a situation where they may have just opened a business. They are investing more than the business is even generating. They're in the red. And so they figure, I don't need to include it. That business isn't worth anything, and it's not going to be worth anything. To the contrary, that business may really flourish. It may grow and appreciate in value. And then you're in a situation where in the future you're arguing over what the value of the business is and who's entitled to what proportion of the business, because it was never properly addressed within the agreement. Certainly we recommend, to the extent either party has a business interest, providing some kind of waivers or really addressing who would be entitled to what portion of that business. This is also important if both parties are going to be contributing to the business financially. You may open yourself up to claims from your spouse if they've contributed to the business financially, either directly or indirectly, if it's not addressed properly within the body of your contract. Another issue that's commonly forgotten or excluded is the treatment of inheritances. Often the parties forget that they may, though they don't have assets at the time they enter into the marriage, they may be subject to acquiring assets in the future via an inheritance, whether it's in trust or out of trust. And so it's really important to include a provision that addresses how inheritances will be treated during the course of the marriage and in the event of a dissolution or a death of one of the parties. Often people or families want to keep inheritances within the family, within the bloodline, and they don't want assets that they've worked hard for, that they pass on to their children, for example, to then be subject to division and perhaps a portion of it leave the family in the event of a divorce. And so to the extent that's the intent of the family or the intent of the spouse, it's important to address that in the agreement so you're not litigating over who has a right to your inheritance. It's also can get particularly confusing if that inheritance was deposited into a joint account or used for the joint benefit of the parties. Another issue that's commonly forgotten is the issue of gifts, whether it's a gift to the parties jointly from a third party, a gift to one of the parties individually from a third party, or even gifts between the parties. This can get very tricky when the parties are gifting perhaps family heirlooms to one another. Perhaps even an engagement ring, right, is a family property or family heirloom that's been passed down for generations. While there may be some case law that helps you with the inheritance or helps you with the gifts, particularly if they're family heirlooms, you want to avoid any surprises. You want to avoid any complications in the future. And the best way to do that is to properly address what your intent is in the agreement so that it's clear, there's no surprises, and everyone understands what their rights and obligations are to the property itself. Other issues that are less commonly included but really should be addressed to the extent they're applicable are lottery winnings or any kind of proceeds from a settlement or an award from a court or a jury, right? So perhaps the party's in a car accident and is a plaintiff in a personal injury case. To the extent there's going to be an award, and it could be a substantial award, the party should really address how they're going to treat that. Is it going to be considered separate? Is it going to be considered joint? These are issues that perhaps the parties don't contemplate, but they could create major complications down the line. So the best way to handle these situations is to seek counsel, explain your position, explain your circumstances, and help come up with a plan that really addresses your specific needs and that of your significant other. So this way your agreement can avoid any kind of confusion, uncertainty, or disputes in the future. I've said it before, I'll say it again. The goal of these agreements is to help the parties come to terms in advance of any kind of problems and hopefully help preempt or resolve those problems proactively. Divorce, the death of a spouse, can be very stressful. There's no reason to add litigation on top of that as an additional stressor. So the best way to prevent that is to have a thorough and comprehensive and properly drafted agreement. If you have any questions about any of these issues, feel free to contact our office. We're happy to work with you to ensure that your agreement really protects you and your assets in a way that's customized to your needs.
Attorney Fox is available 24/7 and can be reached by calling 203-221-3100. You can also email Attorney Fox at efox@mayalaw.com, and please visit mayalaw.com for more information.